Back once again to a paper discussion on all the questions that came from Indian polity in the UPSC Prelims 2025. So without further ado, let's begin our discussion. The very first question. Consider the following statements. Panchayats at the intermediate level exist in all states. Number two, to be eligible to be a member of Panchayat at the intermediate level, a person should attain the age of 30 years. And number three, the CM of a state constitutes a commission to review the financial positions of panchayats at the intermediate levels and to make recommendations regarding the distribution of net proceeds of taxes and duties leviable by the state between the state and the panchayats at the intermediate level. So it's a three statement question, and which of the statements given above are not correct? So the first one, panchayats at intermediate level, of course, these panchayats at intermediate level will exist not in all the states. Why? Because part 9 of the Indian constitution is very clear on this point, that if any state has a population of less than 2 million, that means less than 20 lakhs, then the panchayats at the intermediate level may not be constituted. A very good example of this is the state of Sikkim, where intermediate panchayat level does not exist. So statement 1 becomes wrong. Again, second one is also wrong. Why? Because to be a member of panchayat, you must have attained the age of how much? The age of 21 years, not 25, because the minimum age to contest elections for Lok Sabha and the Assembly is 25. Of course, for Rajya Sabha and the councils is 30. So here it is 21 and not 30, whether it is for the Gram Panchayat or for the intermediate panchayat called the block panchayat or mandal panchayat, whatever, or even the district panchayat or the Zilla Parishad. So 2 is also wrong. Number 3, it is not the CM who constitutes a commission. This commission is the reference to something called the State Finance Commission under Article 243 capital I. And this SFC, like the central SFC or the central FC under Article 280, which is constituted by the president. So, like the central FC, which is constituted by the president, the State Finance Commission is of course constituted by the governor and not the chief minister. This means what? This means this is also wrong. Which of the statements are not correct? D. 1, 2 and 3 are not correct. Right answer is D. Next question. Consider the following statements about Lokpal. Interesting, because this is the first time a question came from the topic Lokpal in UPSC Prelims. Anyway, the power of Lokpal applies to public servants of India, but not to the public servants posted outside India. This is very interesting, because if you read the Lokpal and Lokayukt Act of 2013, the law was passed in 2013. The very first section, section 1 subsection 3, clarifies that this act shall apply to all public servants in and outside India. So 1 is wrong. Okay. Then the chairperson or a member shall not be a member of the parliament or a member of the legislature of any state, which is actually correct. It also goes well with the idea of office of profit, and the members of Lokpal and the chairperson, these posts have not been exempted from the office of profit. So of course this is correct. Now the second part of the statement, and only the Chief Justice of India, whether incumbent meaning the sitting, the present, or retired, has to be its chairperson. Now, this is where there's a factual error in the statement. If you look at section 3 of this law, it very clearly says that to be the chairperson of Lokpal, you have to either be, of course, a former Chief Justice of India, or a sitting or retired judge of the Supreme Court. So we have multiple options. You can be a Supreme Court judge as well, either retired or even a sitting Supreme Court judge. Apart from this, there is one more qualification, that you can also be an eminent person. Now, here, what is the meaning of eminent person? Eminent person here primarily refers to the idea that any person who has impeccable integrity, outstanding ability, an experience of 25 years in various fields like public administration, fields like vigilance, finance, banking, insurance, anti-corruption policy, etc. So there are various qualifications to become the chairperson of Lokpal, and it is not restricted only to the Chief Justice of India. This means 2 is also wrong. Now the third one: the chairperson or a member shall not be a person of less than 45 years of age on the date of assuming office as the chairperson or member, as the case may be. Absolutely correct. The chairperson or members shall not be less than 45 years of age. Section 4 of this very law clarifies this. So 1 and 2 are wrong, 3 is correct. Let's look at the fourth one. Though we have the answer, because 1 is wrong, 2 is wrong, 3 is correct, so A is the answer, but still let's read the fourth one as well. Lokpal cannot inquire into the allegations of corruption against a sitting Prime Minister of India. Now, just to clarify, section 14 of this law talks about the jurisdiction of Lokpal. That means against which categories of public servants can the Lokpal initiate inquiries. So it starts with the Prime Minister. So of course the sitting as well as former. So just to clarify for those who are not aware, Lokpal covers those people who are of course sitting public servants, also former public servants. So sitting and former prime ministers are covered. Of course, there are certain conditions. Now there are certain cases where you cannot inquire against the prime minister. Cases that relate to, say, internal and external security, atomic energy, space, public order, international relations, and there are certain other conditions as well. But the Lokpal can inquire into the allegations of corruption against the Prime Minister as well, right from the top to the very bottom. Group D's, public servants, everybody is covered. Okay, so 4 is wrong. This means A is the right answer. Moving on to the next question, the third one. Consider the following statements with regard to the pardoning power of the President of India. The exercise of this power, pardoning power, which is mentioned under which article? Article 72 of the Indian Constitution. So the exercise of this power by the President can be subjected to limited judicial review. So yes, again, a very, very typically known topic. That is something that every aspirant knows, that yes, the Supreme Court has ensured that such powers are subject to judicial review. In fact, there's a very popular case, E. Sudhakar case. Of course, we have older cases also like the Maru Ram case of 1981, the Kehar Singh case, etc. But in this Epuru Sudhakar case of 2006 versus the government of Andhra Pradesh, a beautiful Supreme Court judgment came. The Supreme Court said that this exercise and non-exercise of the president's pardon power under this Article 72 is not immune from judicial scrutiny. It is not immune. Courts can intervene if clemency decision is arbitrary, it's malafide, or it's based on extraneous considerations, or if this particular power is exercised without the application of mind. We don't know what Supreme Court means by saying without the application of mind, but then yes, the court says that we will review this decision. So the exercise of this power can be subjected to what? Limited judicial review. One is correct. Number two, the president can exercise his power without the advice of the central. That is not possible. This is again subject to Article 74. What is Article 74? The president is bound by the aid and advice of the Council of Ministers. In the Maru Ram case of 1981, the Supreme Court explicitly held that this presidential power or the president cannot act independently in such mercy matters but is bound by the government's advice. So 2 is wrong, 1 is correct. Right answer A, only 1. Moving on to the next question. Consider the following statements on the dissolution of the House of People. The Speaker shall not vacate his or her office until immediately before the first meeting of the House of People after the dissolution. Yes, this is nothing but provisions of Article 94 that we have here. So yes, this is absolutely correct. Now, according to the provisions of the Constitution of India, a member of the House of the People, that is Lok Sabha, on being elected as a speaker shall resign from his or her political party immediately. Now, this is something that we have always wanted. This is something that happens in UK to ensure the independence of speaker. So we have two major provisions in UK that ensure the independence of speaker. One provision is what? That the speaker will resign from his party, or any person who becomes a speaker resigns from their party after becoming the speaker. The second provision is once a speaker, always a speaker, from which we have also seen a mains question earlier. Sadly, this is not the case in India, though I'm sure you're aware that speakers are and deputy speakers, that is presiding officers and deputy presiding officers, are exempted from anti-defection law. This means we have given them this provision that they can resign from their party, which is not available to other legislators. Sadly, no speaker resigns and they continue to serve the interest of the political party, the Lok Sabha, I should say, not the political party. So yes, second statement is actually wrong. There is no provision in the Constitution that enforces this fact that the speaker must resign. If the speaker wants to, however, they are free to resign. So 2 is wrong. Again, if you mark 2 as wrong, we can solve this question because you can simply eliminate 2 and you can get the answer. C is the answer. However, let's read the third statement also. The Speaker of the House of the People may be removed from his or her office by a resolution of the House of the People passed by a majority of all the then members. This is what is known as what kind of majority? This is what is called effective majority, right? Of the House, provided that no resolution shall be moved unless at least 14 days notice 14 days notice has been given. Yes, this is also a provision mentioned under the same article 94 clause 1 subclause C. So yes, this fact is also correct. In fact, you can also refer to this in the rules of procedure and conduct of business in the Lok Sabha. I think rule 11 mentions this very fact, that such resolutions can only be moved after giving 14 days of advance notice. This means that 3 is correct, 1 is correct. Right answer, as we had established earlier, is C. Moving on to the next question. If consider the following statements. If any question arises as to whether a member of the House of the People has become subject to disqualification under the 10th schedule, the President's decision in accordance with the opinion of the Council of Union Ministers shall be final. Sadly, this is incorrect. Why? Because as far as other kinds of disqualification under Article 102 are concerned, that is the first clause of Article 102, be it office of profit, be it bankruptcy, be it unsound mind, not being a citizen, or any other law made by the Parliament. In all those circumstances, the president's decision is final. However, it is on the opinion of the ECI, the Election Commission of India, not the union ministers. But when it comes to 10th schedule, which is anti-defection law, we know very well who has the final authority. The deciding authority under such cases is the presiding officer of the house. So one is wrong. Second one, there is no mention of the word political party in the constitution. Of course, when you deal with schedule 10, the word political party is mentioned under this schedule 10. So 2 is also wrong. This means D, neither 1 nor 2 is the right answer. Moving on to the next question. So, consider the following statements. Statement 1. In India, state governments have no power for making rules for grant of concessions in respect of extraction of minor minerals, even though such minerals are located in their territories. Now, this is very basic common sense that minerals are a stateless subject. If you refer to the 7th schedule, the 7th schedule is what? Under Article 246, we have the division of power into 3 lists. So one such list is the list 2, the state list. Under state list, if you find an entry number 23, it refers to mines and minerals. So minerals is a stateless subject. So how can the state governments have no power? So of course the statement is bogus anyway. Also, if you look at the Mines and Minerals Development and the Regulation Act, Mines and Minerals Development and Regulation Act of the year 1957, you'll come to realize that it expressly empowers the state government uh, to make rules for regulating the grant of quarry leases, mining leases, or other mineral concessions in respect of minor minerals. So one is wrong. Now, in our previous discussions, I've always maintained this point that when it comes to such statement based questions, you will always find, as far as polity is concerned, that one of these two statements would be wrong, and hence the answer is going to be either C or D. This means what? In this case, statement 1 is wrong, so statement 1 is not correct, but 2 is correct, hence answer is D. That's it. Let's also read statement 2. In India, the central government has the power to notify minor minerals under the relevant laws. Of course, yes. In fact, the same MMDR Act of 1957 has a section 3. Again, these sections need not be mucked up by any aspirant. You can see that this question could be solved by very basic common sense. But just for your information, the same law has a section 3 which says that minor minerals will include any other minerals which the central government may notify. So this is correct. Right answer is D. Moving on to the next question with reference to the Indian polity. Consider the following statements. An ordinance can amend any central act. That's true. Ordinance under Articles 123 and what? 123 and 213. So yes, ordinances can amend any central act. That's true. One is correct. An ordinance can abridge, reduce, take away a fundamental right. No, this is now wrong. Why? Because Article 13 very clearly says that the state shall not make a law which will abridge, take away any fundamental right mentioned under, of course, Part 3. And the same Article 13 Clause 3 says law. The word law will include various things like ordinances, orders, bylaw, rules, regulations, notifications, custom, etc. So ordinances, which are also like laws, cannot take away your fundamental rights. Now, question that comes in our mind is, can our fundamental rights be taken away? Yes, they can be taken away, but only through a constitutional amendment which will follow the procedure of Article 368. So 2 is wrong. Again, this question can be solved directly here. Why? You simply eliminate 2, 2 only, 2, 2, all wrong. Right answer is C. Very simple and easy. An ordinance can come into effect from a backdate. Yes, any ordinance of a civil nature can come into effect from backdate is also correct. Moving on to the next question. This is consider the following pairs. Now, this is more of a GK type question than actually a polity question, though the second and third options do relate to polity. So, Arunachal Pradesh, you have states on one hand and description on the other side. Let's see how many of the above pairs are correctly matched. Arunachal Pradesh, the capital is named after a fort and the state has two national parks. Now, yes, this is a factual statement and this statement is actually correct. Arunachal Pradesh, the capital of which is Itanagar, is named after the Eta fort, meaning the fort of bricks, Eta. And this was, I think, constructed way back in the 14th century. Yes, the state has two national parks, the Namdapha National Park and the Moling National Park. So, yes, the statement is correct. Then Nagaland, the state came into existence on the basis of a constitutional amendment act. Yes, of course. In fact, you have a special provision for Nagaland. Back in 2013, a mains question came from this topic, 371 capital A. And yes, the 13th Amendment Act of 1962 was the one which led to the creation of what? The state of Nagaland. So 2 is also correct. Though I'd remind you once again that statement 1 is a very factual statement, but 2 is something that you would know. And then the third one, Tripura, initially a Part C state. Yes, we had 10 Part C states. One was Tripura. It became a centrally administered territory in 1956 after the reorganization and later attained full statehood is also correct. It in 1972 became a full-fledged state. So 3 is also correct. Now see, if you have been following polity, you can solve these two questions or make at least mark these two as correct. This would mean that the answer can either be B or C. Now in such cases, when you have eliminated two options, always take the chance. Always mark the answer. Always. Never skip questions where you have come to 50-50. Yes, the only guarantee should be that the ones you have eliminated should not be the correct answer, right? So that should not be the case. Otherwise, always take an attempt. You'll always be on the winning side in the longer run. That means in the course of our solving the entire paper. So here C is the right answer. All of them are correctly matched. Then moving on to the next question. With reference to India, consider the following bodies: Interstate Council, the National Security Council, and the Zonal Councils. Okay. So how many of the above were established as per the provisions of the Constitution of India? So some things are very simple. The Security Council, of course, is not a constitutional body. It was established in 1999. It's an executive body. So executive body goes away. Zonal councils are statutory bodies. They were all established under the States Reorganization Act of the year 1956. Remember the 7th Amendment Act, the Fazal Ali Commission. So, of course, this is also gone. This is gone. Right answer is what? A. Only one interstate council, which was established on the recommendation of Ranjit Singh Sarkaria Commission in 1990. And this provision is also mentioned under Article 263. The president can set up the or establish an interstate council if he believes it serves public interest. And then the president can also specify the duties, the organizational structure, procedures to promote center state cooperation, interstate coordination, right? So, one, the interstate council is the only body established as per the provisions of the Indian constitution, right? Is the answer. Next question. Consider the following statements regarding constitutional provisions in India. Okay. The Constitution of India explicitly mentions situations where the governor of a state can act in his or her discretion. Okay, interesting. And this is, of course, correct. Article 163 mentions this specifically, that the Constitution has given to the governor this power to act on his own discretion. I give the example of Nagaland. You can look at all these various articles, say the articles ranging from 371, 371 A, B, C, D, H, Arunachal Pradesh. You can look at all these situations, maybe the consideration of bills for the president, etc. There are various places in the constitution where the governor can act in his own discretion, right? So one is correct. The President of India can, on his or her own, reserve a bill passed by a state legislature for consideration even without it being forwarded by the governor of the concerned state. Now, of course, in the recent times, we have seen the very famous, or the infamous case rather, that's governor of Tamil Nadu versus the government of Tamil Nadu, where the Supreme Court gave a judgment trying to interpret the constitution by not a constitutional bench. But again, we have the case which was declared by Supreme Court, and then we also have under Article 143 the presidential reference sought from the Supreme Court. Supreme Court is going to go on vacation shortly, and then post the vacation we might see some arguments in this regard, but that's a story for a different day. My point here is, yes, in the recent times we have seen that this is related to Article 200 and Article 201, and yes, there it is only that the governor is empowered to reserve the bill in certain types of cases. For example, a case maybe which relates to the abrogation of powers of High Court or other matters. Now, in those cases, the governor reserves the bill for the president's consideration. Absolutely correct. And this is possibly the reason why this question was asked. That could be your thinking. However, this would make this question statement incorrect, because it is not the president who can do it on his own, but the governor will reserve the bill for the consideration of the president. However, let's not forget there is an Article 360, because this question talks about constitutional provisions. It does not relate to a very specific domain or an area. Now, Article 360 is about financial emergency. And if you refer to Article 360 Clause 4, you'll find that it says that notwithstanding anything mentioned, notwithstanding means in spite of whatever is mentioned in the Constitution, the President can issue directions, which can include, of course, the very first part is interesting, that the provision requiring the reduction of salaries of any class of persons, right? So yes, during a financial emergency, the salaries of any class of persons can be reduced on the direction of the president, but that's of no concern to us. The second part is of concern to us. I'm specifically referring to Article 360 Clause 4. Second part says that the president can give directions that on a provision that requiring of all money bills or other financial kind of bills to be reserved for the consideration of the president after they are passed by the legislature of the state. Now, in that particular phrase, there is absolutely no mention of the governor. So, broader constitutional provisions actually make this statement correct, that the president can, during a financial emergency, direct that certain bills be reserved for his consideration without the governor forwarding the same. Uh, in this circumstance, of course, the answer can be either A or C. I would leave it to Supreme Court's or UPSC's judgment, because when the answer key comes, that's the time we'll come to know. And even if UPSC marks the answer as A, that is not a very good answer to mark. In fact, the correct answer ideally should be C for this question. But again, keeping the recent context in mind, some people might feel that this is an over interpretation, but this is not over interpretation. It is just a very generic understanding of the constitution with wider knowledge. You can also mark A as the answer. We'll have to wait for UPSC to give us the final answer, and whatever they say is something that we'll have to follow anyway. But yes, any logical, wide understanding mind would agree that yes, since this is not very specific to a certain type, this question would also incorporate this idea, and then in that case it is very much possible that second statement should be correct. Anyway, we'll have to wait for UPSC's answer key, that is 1 full year. So moving on to the next question, consider the following pairs: provisions in the Constitution of India and the stated, and its second column is stated under. So separation of judiciary from the executive in public services of the state. Is it mentioned under DPSPs? Yes, of course. Article 50, right? This talks about the separation of the executive and the judiciary. This is the reason we had the CRPC 1973. Valuing and preserving the rich heritage of our composite culture. Yes, this is again a part of fundamental duties. Article 51A, clause F, right? Fundamental duties added in the year 1976 on the recommendation of Sardar Swan Singh Committee. So 2 is also correct. Prohibition of employment of children below the age of 14 years in factories. Yes, this is also correct. It is mentioned under Article 24, right against exploitation as 2 provisions, 23 and 24. All 3 are correct. C is the right answer. Easy, simple question. So you see, most of these questions are simple in nature. Not much of complication. In fact, we don't have the 2023 dangerous kind of questions where how many are correct. You can simply eliminate and solve. So the paper is relatively simpler if and only if you had revised properly, and there is nothing that was not taught. I would not like to make all these claims that, oh, all things came from my notes. Any informed faculty would have taught all these things. These are all mentioned in standard books. So this time the polity questions were not that challenging. In fact, a lot of them were quite easy, barring the Arunachal statement, which required factual knowledge. That is true. And one which has a slight confusion. Other statements are relatively easier to solve, and questions also easier to solve in general. So neither too easy nor too difficult, moderate level questions, right? Yes, I would also say that the last year's paper was slightly easier, maybe that is possible to assume that it was easier than this one. But again, this is also one of the, I would say, easier papers to solve as far as polity is concerned. Now, consider the following statements regarding scheduled areas under the 5th schedule of the Indian Constitution. If an area in a state is declared as a scheduled area under the 5th schedule, the state government loses its executive power and a local body assumes total administration of such areas. Interesting. I mean, see, these are extreme statements. The state government loses its executive power and local body assumes total administration of such areas. No, that is not true. So we all know the provisions of scheduled areas. In fact, this has been a cause of concern that the state government still hold a lot of control over these scheduled areas. And when you talk about a scheduled area under 5th schedule, we have local advisory bodies called the Tribal Advisory Council, right? It is not the 6th schedule which has the ADC, which has been given lot of powers. I mean, ADC, if it was 6th schedule, it could have been a possible confusion in the mind of aspirant that, oh, maybe the ADCs, the autonomous district councils, do have legislative functions, executive functions, financial functions to perform. Might be true, though that's false in that case also. But here, the complete control is lost. Of course not. The TAC is just an advisory body, right? So one is wrong. Union government can take over total administration of such areas under certain circumstances on the recommendation of the governor. Now, see, in this case again, the union government taking control of the total administration under certain circumstances is not a provision mentioned under the fifth schedule. Now, here, if somebody tries to over-interpret, they might say, but sir, Article 356, President's rule, but then you are over-interpreting because the statement refers to fifth schedule. The question talks about fifth schedule. So, incorporating other provisions might be wrong. So, 2 is also incorrect. There is no such provision. So, both statements are wrong. Right answer is D, neither 1 nor 2. See, as I was mentioning, constantly questions on the easier side, lot of logic can be used to solve these questions. Moving on in this fashion to the next question, consider the following statement or following subjects under the Constitution of India. List 1, union list in the 7th schedule, extent of the executive power of a state, conditions of the governor's office. Okay. So, for a constitutional amendment with respect to which of the above, ratification by the legislature of not less than one half of the states is required. This means which of these relate to, what is that word? Federal structure. So, Article 368 provides for, Part 20 provides for the amendment procedure. Under Article 368, we have a clause 2 which mentions this very specific case. That means which all areas are the ones where this amendment or modification would require half the state's ratification. So you have Articles 54 like the election of the president, the electoral college, Article 55 manner of election, Article 73, 162, so many of them. Then chapter 4 of part 5, which is the Supreme Court, High Courts, the extent of executive power of the state, etc. Any of the lists mentioned in the 7th schedule, this, right? Then the representation of states in the parliament. In fact, Article 368 itself, if you want to amend the provisions of Article 368, you need to send it to send it to all the states, and the moment half the states approve, the task is done. So 1 and 2 are correct. Conditions of governor's office, not really. I mean, we have borrowed the provision with respect to governor's office largely from Canada, at least the appointment part, and that is one area of concern because since we call our constitution more quasi semi-federal, very unique kind of federation where it has a strong centralizing tendency. So governors are appointed by the center, etc., and this is not something that would require states' consent. So 1 and 2 are correct. It simply is a provision lifted from this article. Factual question. So 1 and 2 are correct. Right answer would be A. Right? Moving on to the next question with a reference to the Indian polity, and this is the last question that came from polity. With reference to the Indian polity, consider the following statements. The governor is not answerable to any court for the exercise and performance of the powers and duties of his or her office. Yes, absolutely correct. Which article is this? Again, this is Article 361, special provisions, immunity for the governor and the president. Then no criminal proceedings shall be instituted or continued against the governor during his or her term of office is also correct. This is a statement which was asked earlier also. In the year 2018, there was a question in the prelims which had the second statement as this one. Okay, so 2 is also correct. Members of the legislature are not liable to any proceedings in any court in respect of anything said or any vote given in the legislature or its committees. This is also correct. So this is Article 194, the parliamentary privileges mentioned under 105, and the same privileges have been extended to the state legislators as well under Article 194. Though recently in the Sita Soren case, some modifications have been made with respect to interpreting the aspect of voting, where the court said that if voting is being done due to bribery and stuff, then yes, the court can intervene, but nothing with respect to anything said or any vote given. So they are not liable to any proceedings in any court in respect of anything said or any vote given in the legislature or any of its committees. Right answer is D, 1, 2, and 3. So all these ultimately mean what? All these ultimately mean that the answer is D, 1, 2, and 3. And this brings us to an end of our discussion on the question that came from Polity in 2025. I hope you loved the session. I hope you have also understood how following very basic resources, just mugging up the same things over and over again, not going crazy in bonkers from multiple things, etc., collecting or going on this journey of being a notes collector, moving on from being a district collector to a notes collector, you can very easily clear the cutoff. I would not be surprised that any informed aspirant who limits his resources, revises properly, solves multiple mock tests, would be able to solve most of these questions easily. Okay, so that's all for this video. We'll meet in some other video. Till then, that is all for me. Jai Hind.